Hello, I'm attorney Lewis Haskell, and I'm often asked when people call on the telephone, how much do you charge for a trust? And my answer is often, I don't know. Why do you think you need a trust? And most of the time, the answer is along the lines of, well, my friend got one, or my financial advisor told me I should have one, or I read something online saying that trusts are a good idea. And so then I ask the following question. Okay, well, what do you want your trust to do? For most people, the answer is, I want to avoid probate. Now, that is a perfectly fine answer, and there is a perfectly good trust available to do that. It's called the Revocable Inter Vivos Trust, sometimes called the Living Trust, and it's a wonderful document. It leaves you completely in control of all your assets, all your money, whatever you put into the trust is yours. You can appoint yourself trustee. You can amend the trust at any time. You can revoke the trust, get rid of it at any time. All the power is yours. But sometimes, oftentimes really, when I'm discussing how wonderful this is, everything is going great until I make the statement, but of course, it doesn't protect your assets from creditors, and it certainly does not protect your assets from mass health if you want to go into a nursing home. Those are different types of trusts. Those are known as irrevocable trusts, because once you put your property in them, you, generally speaking, cannot take it back out. That trust is immortal. It's irrevocable. So it's very important, before even beginning a conversation with an attorney or any form of an estate planner, but an attorney, to try to figure out what you're trying to accomplish, because there are very significant trade-offs. And let me see if I can flesh this out a little bit better. With the revocable trust, you have no creditor protection in life, but you do have creditor protection in death. Since the property in the trust never enters your probate estate, since you have avoided going into probate, which so many people try to avoid for really excellent reasons, your creditors can't get at it in probate either. So that is really good. But one thing that confuses a lot of people is that there's a difference between your probate estate and your estate tax. And people get confused because, after all, the word estate is in both of them. Both of them are really only important when you die. So people assume that if they avoid probate, they avoid estate tax. And that's not necessarily true. I say not necessarily because the good news is the federal estate tax exemption is now $11.5 million. So for most people, federal estate tax is not an issue. Unfortunately, here in Massachusetts, we tax all estates that are more than $1 million, and our definition of estate size is a little bit weird. On the federal side, it's whatever you have when you die, and if you've been giving things away, we simply reduce that $11.5 million number. In Massachusetts, it's what you have when you die, plus it's all the stuff you gave away that reduced that federal number, which does create an interesting situation because, for example, if you give your house to your children right before you die, it leaves your taxable estate, but it still counts towards the $1 million. So it's possible that you could have a situation in which you die with less than $1 million in your estate, but you're still paying state tax. It's not a $1 million exemption. And I mention all of that because putting things into a revocable inter vivos trust, a living trust, really doesn't help out much in terms of estate tax planning in Massachusetts or federally. Similarly, if you file bankruptcy, bankruptcy trustee is going to treat a revocable trust as if you own the property. Again, Mass Health. You have all these different places. However, let's say you're young like me. You're middle-aged. You're under 65, certainly under 70. Creating a revocable trust, and especially a Medicaid trust, the type of trust that you use so that you can go into a nursing home, can be problematic. After all, these trusts are irrevocable. Once you put the property in, it can't come back out. And if you're talking about a Medicaid trust, oh my goodness, you can't be getting income from the thing. You can't, you can't exercise really any power or control whatsoever. So you really have given it away. Now, having given it away, you've accomplished a number of things on the estate tax side, on the probate side, on the creditor protection side. And if you've given it away in time, which is say more than 5 years before you're going into a nursing home, you've accomplished great things in terms of Medicaid planning, getting Mass Health to pay for your nursing home and then not having to reimburse Mass Health. The problem is you've given it away. And if you're, 50, 55, 60, 65 years old, you may not want to be putting all your property out of reach. If you're wealthy enough, you may want to be able to put some of it out of reach, but all of it is a lot. And you really need to be trusting this person who you're putting in control because they're in control. You have given it away. You've given it away irrevocably. It is gone forever. And so that becomes a problem even when you're talking about something as simple as your house. Not being able to get income from your house is not a problem if if it's a single family residence, it's just you or you and your family living in it. It's not drawing income anyway. So, being told that, for example, for Medicaid purposes, that you can't have the income isn't a problem. However, by putting it in the irrevocable trust, you've now lost the ability to sell it. You've lost the ability to refinance it. You've given up control. Now, maybe your trustee would do some of these things, but maybe not. And in any event, that's not your decision to make anymore. So, if you're in a situation, and I certainly have had any number of clients who really and legitimately were in this situation where they wanted to own this house until the day they died, that they have lived in this house for a very long time, in some cases all their adult lives or almost the entirety of their adult lives, and there was no scenario in which they were going to sell that house. And there's frankly no scenario in which they were going to mortgage that house or refinance that house. Then sure, placing the house into an irrevocable trust may make some sense. It may be the right thing to do. It's one thing to be 70 and saying, I'm never going to sell this house. I'm never going to live anywhere else. I want to own this house until the day I die. I'm never going to put a mortgage on this house or refinance the house. In fact, age 70, there's a good chance you have no mortgage to refinance. It's a completely different thing if you're 40 or 50. You may need to move for reasons that you haven't really contemplated. You may run into any number of financial hardships or financial opportunities. There may be this great investment property that comes down the line that's just too good to turn down. And even though you have no mortgage on your house, you want to tap that equity to get at it. Again, you may think that you're a master of the universe and will never have a financial problem, and therefore would never want to draw money out of your house. But that can change. One of the things I think the COVID-19 pandemic has shown us is how quickly things can change. I remember during the financial crisis, I had clients come to me, who only 6 months or a year earlier, had solid six-figure incomes, figured they would never have another financial problem in their lives, but they were realtors or mortgage brokers or somehow tied to the housing market, and suddenly found themselves with no income whatsoever, and in having all kinds of financial difficulties. I was taking a lot of these folks into bankruptcy, even though, as I say, a year earlier, they were living the dream. So, putting assets into an irrevocable trust when you're younger, even, and by younger, I mean middle-aged, may not always be the right thing to do. Of course, there are great estate planning tools, estate tax planning tools and whatnot that are available that really do make sense for a younger person. Life insurance trust, for example. In fact, it stuns me that when I had bought, my life insurance, policies many years ago, none of the insurance agents ever suggested a life insurance trust. And they really should have, especially the one who sold me $1 million policy, because that policy in Massachusetts is countable. So in other words, the day I bought $1 million policy was perhaps the day that guaranteed that if I were to die during the term of that policy, I would be paying Massachusetts estate tax. But if that policy had been bought in the name of a life insurance trust, sure, I lose power over that policy, but that's really particularly not what term life insurance is for. In other words, I'm not buying that life insurance policy for me. I'm buying it for my wife and kids, or for, the people who I care about after I die. So the fact that I have put, what is essentially nothing out of my reach is not a problem at all. But the idea that all that's counting against, well, really nothing's counting against my estate, because I suppose what I pay into the trust to purchase the policy would be characterized as a gift, because that is less than the $15,000 federal gift tax limit that is so well known. It doesn't count as against my federal state tax limit. It doesn't count against the $1 million Massachusetts limit unless I'm also giving away, a lot of other stuff. So again, the question of what does a trust cost really is a function of what are you trying to do? What are you trying to accomplish? And really, if you haven't thought that through, is really part of a larger conversation about what you're trying to accomplish financially in life and in death, and in terms of taxes, in terms of probate, in terms of a lot of different moving parts. And if this video has confused you at all, then you understand that it is a lot of moving parts. You may understand that I'm also inarticulate, but a lot of moving parts, there are a lot of different considerations, many of which I've kind of sort of discussed in this video. Others you know, are more personal, more private, and really just are kind of outside the scope of a, you know, of a little, you know, video such as this one. But please try to think about some of these things. And if you would like to discuss them further or try to, you know, or want to set up a consultation to come in and try to figure out what it is that you need. And as importantly, what you don't need or don't need yet, but may want to think about for some time in the future. You know, just know that I'm available, and you're welcome to call me, to come in and meet with me. Or, although phase 3 is starting, we are very happy, in fact, kind of prefer to do, you know, video conferences, telephone conferences, these sorts of things, because I do want to keep you and my staff. Many of my staff have come back to the office, have come back, you know, to be physically present here, and I'd like to keep them safe too. So please feel free to give us a call, and until then, please be safe and please be strong. Thank you.